I think we're good to go.
Okay, well, I'll kick us off then. Thanks everyone for joining us today on our IP 101 seminar. My name is Hannah Klitz and I'm the communications coordinator for the Combine. So we're excited to have Matt Polson here with Suter Swantz today to talk about IP and is specifically focused on the startup side of that as well. But before I turn everything over to him, we wanted to just introduce the Combine to anybody who's not familiar with our organization. So we are an ag tech incubator located in Nebraska, and we support high growth food and ag tech startups across the state of Nebraska. So with that, it looks a little different for every company. We accept people, entrepreneurs on a rolling individual basis, and then we really tailor the curriculum based on where they're at and meeting them where they need to be. And one of the biggest questions we ask is, how can we help you? And then alter our programming from there. But we also have an incubation space located on Nebraska Innovation Campus in Lincoln. And then the operational assistance with those one-on-one meetings. Josh Stimmers, our program manager who's on today, leads those now and works specifically with the startups. And then I also assist some with the marketing side of things for our startups. And our Nebraska Farmer Network is one of the biggest benefits of being in the Combine that we've heard from like the founders over and over again. So this is called our Insights Network, and we have a whole segment of farmers across the state of Nebraska in varied industries so that our startups are able to use them for customer discovery or pilot programs, on-farm trials, and things like that. So if you'd like to learn any more, please use this QR code or go to nebraskacombine.com. And I know Jessie with Nave Analytics is on the call today, so hopefully she doesn't mind me using her photo here, but we appreciate that. So I'll hand it over to Matt now and let you take it away, Matt. We are planning to do a question and answer at the end of the call. So if you're on here and have any questions, please feel free to drop those into the chat. Perfect.
All right. Thank you, Hannah. I got to make sure. Can you see that? Just want to make sure you have it.
We cannot see it yet.
That's weird. Okay. I lost my sharing there.
There we go. Now we can see your screen.
I got it.
Yep, can see it now.
All right. Well, thanks for having me, Hannah and Josh. Great to be online with everyone. So quick introduction. As Hannah said, my name is Matt Polson. I'm a patent attorney in Omaha at Suter Swantz. Also teach patent law at the University of Nebraska Law School. So I'm used to PowerPoint slides and talking online and all that, but always great to talk to a different group, and I'm familiar with the Combine. We've worked together quite a bit over the last several years. So again, thanks for having me, and I'll just get going here. So I guess as a bit of a warning, I tend to include a lot of slides and a lot of information. My theory is that sometimes, well, not sometimes, probably all the time, people catch about 25% of what you say. So it's better to have more slides than not, so you can go back and have a nice reference. So just to start off, intellectual property, what are the types of intellectual property? I know a lot of people are going to be somewhat familiar with this, but just as a high level, and we'll kind of drill down. We're talking about patents, trademark, copyrights, trade secrets. Patents, of course, are your inventions, your unique designs, potentially. Trademarks are covering your branding, your logo. Copyrights are protecting, works of authorship, writings, artwork, code, potentially. And trade secrets, just as they sound, are those secrets that are potentially valuable that you can keep secret. There's a lot of overlap. There are certain things that can be patented that can also potentially be protected under trademark or copyright law, and obviously also a trade secret law. So there's always a balance in terms of what you need to look at. I mean, sometimes it's a cost question, sometimes it's a enforceability question, and sometimes it's a practical question. Right? How likely is you're going to be successful in a particular regime? So, with that, I mean, the most important, I think, is trademarks and patents. Actually, patents and trademarks that we're talking about in order. And that's what we're going to focus on. And so certainly questions, if you have questions down at the end of this about any other areas, I'm happy to discuss that, but we'll focus on patents and trademarks for now. So, why do we worry about IP? Sometimes that feels like an obvious question. The answer may at an elementary level, like, oh, it's always good to have IP. It's not bad to have IP. But with everything like that, there's a cost to it. If you just were giving out patents, of course, everybody would take one. But that costs a fair amount of money and a fair amount of time. And, you have to, ask yourself why you want them, and trademarks and copyrights for that matter. But first level, it establishes a moat, right? It just keeps competitors away from your central product or your non-central products as you grow. That part, I think, is the obvious part. The other piece, which is a little more subtle, is they serve as a nice defensive tool. Especially when you're a startup, small company, you're not going to be able to go out and sue Google or John Deere or whoever it is. Now the entity that acquires you may down the road, or you might be able to 7-8 years down the road after you've grown and are sizable. But at the outset, you're not going to want to enter into patent litigation or trademark litigation. But a defensive tool, the defensive tool aspect, for us older folk that remember the Cold War, this is kind of the Cold War model of IP, which is, hey, I build a portfolio so that person that also has a portfolio doesn't go after me, and we just kind of agree not to sue each other and destroy each other. We just kind of two entities of equal size that are kind of coexisting in the market space. That is one really possibly the most utilized version of at least patent protection that there is. It's pretty valuable. The other part of it is, why you have to worry about IP is even if you don't want to go file an IP, you have to be cognizant of the fact that other companies have IP. So at a very minimum, you've got to be worried about infringing others' rights, because whether you want to deal with it or not, if you're just go out and ignore IP and you go and start building something, and then it's infringing on somebody else's patents, you're probably going to hear about it. And you'd rather answer those questions early on than later on. And then the final and very, very practical part is that it helps with investment and acquisition. Looks like I spelled acquisition wrong there, but that is the very practical part that right now you're going to be worried about. The investors. I mean, and I have met investors. I know investors. I have listened to conversations where I've heard investors tell a founder, "Oh, I don't care about IP. I don't care about patents. I just want we just want to go fast." And then as soon as there's some investment on the table, I've seen that exact same investor, come back and say, well, what kind of IP do they have? We do due diligence on their IP. So while they might say they don't care about IP, they absolutely care about IP. And there are some statistics here to kind of back that up. A few random pieces of data that you got to be careful about causation versus correlation, and that I'll admit that right out of the gate. But 80% of startups receive venture capital hold patents. Having at least one patent application reduces the time to the first venture capital investment by 76%, which is pretty precise. And then on average, startups receive over 500K more per investment more in investment dollars per patent. All again could be correlation more than causation, but general point is it's better to have patents than not. And just anecdotally, I can just tell you that the investors and future acquirers very much care about IP. It's IP due diligence is one of the very first things that you talk about when there's a big investment coming in or acquisitions on the table. Now, like I said, we're going to talk about patents and trademarks. So we're going to be the big focuses here. So patent kind of high level overview, if you will. We'll talk about, we're gonna talk about some pitfalls, and I always put this last because it kind of sequentially makes more sense. But if you really just come away with one slide in your head, this is probably that conversation, or that section is probably the most important, because patents can be unforgiving, or the patent law can be somewhat unforgiving. We'll talk about different types of patents and ways in which to protect that IP. Then, of course, we'll talk about the general patent process and timing, and then some standards for patents. But so this is the slide that I was talking about. Just be aware of, your event or your activity can bar you from getting a patent, and I think that surprises some people, that there's this sense, natural sense that, well, if I built it, I can do it for however long I want, and then when I eventually want to get around to it, I can go file on a patent, and that's true for trademarks, and that's true for copyrights. But it's not true for patents. But at the outset, it just understand that once you start making, or once you start publicly disclosing, offering for sale, using in public, you are generally barred from getting a patent in the United States. Now, the US has a 1-year grace period to guard against that. There are some requirements to meet that rule. But generally speaking, in the US, we can get you a 1-year grace period to apply, to apply, so that you do have a little bit of forgiveness there. But it's only 1 year forgiveness. You can't wait forever. But in most foreign countries, which it's a global economy now and has been for a while, if you're doing anything overseas, whether it's selling or building, you're likely going to want some form of foreign protection. And most foreign countries have what we call an absolute novelty set of rules, which means as soon as you do any of these things, you're forbidden from getting a patent. So it can be pretty unforgiving. So what do some of those things look like? And these things happen, and it is not uncommon for someone to come to us. Hey, we've been active for about 3 months. We've been selling for about 3 months. It's going great. We want to file a patent. Again, in the US, you'll probably be okay, but not forever. But again, foreign, you're not. So typical cases: public disclosure. You have a website, you're selling products, services, whatever you're selling. If you public pitch, which is obviously very common in the startup world. If you go into a conference, trade show, one of them that surprises people are grant applications. That those can be considered public disclosures, even if they're confidential at the time. Most of the case law that you would read on this would suggest that the key factor is whether or not that information can be had through a Freedom to Information Act request. If that information can if a person can get to that through that type of request, then that grant application could be considered a public disclosure. And it's based on the date that the grant application was submitted, not on the date of the Freedom of Information Act request. So that seems a little unfair, and it kind of is, I think, unfair. But that's how the case law has come out. I always say can, because case law is kind of fickle sometimes, and you can get different outcomes based on what your facts are in different courts in different districts. So it's just something that you need to think about a little bit. Public use. I think that sounds pretty obvious to most. If you're out there, you invented a new vehicle and you're driving around the streets of Omaha or Lincoln, those are going to be considered public use, right? Now, one caveat: public use doesn't necessarily be publicly known. Now, that doesn't apply when you're talking about mechanical inventions. Those are very, very observable. But it does apply when you're talking about something a little more secretive. So say you're working in the precision ag world and you have some really cool algorithms that are running in the background that nobody sees, nobody has access to, but those are potentially patentable. even though nobody sees it, that's still considered public use because they're being used publicly in the way you would, right? You're not streaming those on your website for everybody to see. So the way in which it's consumed by the public, that's going to be considered public use. Offers for sale, general threshold I kind of use is, and it's not necessarily a black and white one here, but was there a price quoted? There's no price quoted. Yeah, it probably isn't considered an offer for sale. Another caveat for this one is an offer to license a patent, or offer to sell the company. Those are not offers for sale. We're talking about the product itself. The invention that you were talking about itself is really what we're talking about there. So those are all things you have to be wary of, and you have to make sure that you have a filing date. Ideally prior to any of these events. If you miss that, which is not uncommon for startups at all, but if you miss that, then you need to really make sure that you get it within that 1 year. Otherwise, you will likely be barred. Then there are some details in there that we can talk about.
Hey, Matt, before we move on, we do have a couple questions from the audience. So Ryan Anderson asked, what factors constitute a public pitch?
Public pitch. Yeah. So that's a, I don't think the question of public pitch, the lawyer's answer is, I don't think the question of public pitch has been litigated. So it's not 100% clear, but based on other types of cases. So there's a semi-famous, to the, for patent lawyers, I guess, semi-famous case where there's a setting, an academic conference where researchers went to this conference and gave a talk, and as conferences go, you can get some sessions that aren't very well attended, and there were 7 people in the audience, and that was considered a public disclosure. But one of the other factors was that they handed out printed material, and so together they considered that a public pitch or public disclosure. I guess my point is if it, my question is it in a boardroom with some investors and you're talking in what would most reasonable people would say a private setting, or are you in an auditorium on a stage and there are 5 or 6 people there? I think the latter would probably be considered public disclosure, even though there are not many people there, and the former probably private because everybody views it as private, but it's a gray area. And in a lot of settings, if you have an NDA, that's one factor that would go into it for sure, because it's pretty written at that point that everybody assumes that that's a private conversation. And so there's kind of an expectation aspect to it, but it's not clear, and pitches get kind of funky because a lot of these things are informal and it can be hard to tell.
Awesome.
Not sure that helped.
And I mean, they can always ask more questions here following up on that. But Daniel Shotman asks, please expand on the grant application point. Are NSF and USDA subject to FOIA?
Good question. I don't 100% know the answer to that, but I believe the NSF is, and USDA also, I think it is. I don't take my word for it. You can usually contact the entity providing the grant, and they'll give you an answer, black and white. And then, in fact, some entities, I think Nebraska does it, is better about. They actually say, they'll tell you that it's not subject to a Freedom of Information Act request. I don't 100% know the answer to that. So I don't want to tell you yes or no because I don't want you to rely on it. But I think you can reach out to somebody at either or both entities, and they should be able to provide that information.
Perfect. And we have one more last question on this topic. Mark Goes asks, does a prototype grant for development of a product disqualify you?
So the prototype grant, again, don't take my word for it here, because this is getting close to legal advice, but the prototype grant, depending on where it is, Nebraska's, for example,
yep.
I recall somewhat recently having a client that went through this same analysis, and he was actually given information from the entity that indicated that there was no Freedom of Information. It was not eligible for Freedom of Information Act requests, and therefore that wouldn't be create a bar. But you should confirm with that whoever you're getting the grant from to make sure that's the case. And then the next question was the development of the product. So when you, again, I'm assuming this is the typical hypothetical case, which is you have a product, you've designed, or you've sketched it out, you're wanting to take it to somebody to actually design a full-blown kind of quality prototype. Typically that would not be considered public. And hopefully you have an NDA in place with that entity to help evidence that. And in addition to that, and this is getting off on a tangent a little bit, make sure you have some sort of a rights assignment so that you own the ultimate design of that, and not the contractor that you're bringing on board to help with the design. But generally that's not going to be considered public.
Got it. And I have a quick question as well, Matt, on this. So what would you say would be the process for a company that, has, created or sketched up a product and they want to go apply for a grant, but they don't have, say, a patent on it yet? What would be, your advice in terms of how to proceed? Is it more of, hey, let's get a provisional patent in place and then go to the grant, or do you contact the grant to see if the FOIA applies?
Yeah, so I may have missed a little very last bit, but I think I got the general point here. And the general suggestion, and we run through this all the time, is to get a provisional patent application in place. At the end of the day, you can't change the law, and you have to act. So you have to find out what the least worst case is, and that's probably getting, rushing to get some sort of provisional patent application in place. And I do have some slides down the road on this point, and on that we can talk about that a little bit, but at that point, but it's going to be, then that's why provisionals are nice, is you can get a provisional in place and still keep working. You get a provisional on what you have, with the understanding that that product may evolve a little bit before you ultimately go to market. But that's typically how I would handle that.
Great, thank you, Matt, and I'll let you know if more questions arise.
Okay, sounds good. All right. So moving along here. So we talked about the bars that we have to worry about, and that, again, that's the most important slide, the one we just came across, or just left. What are the types of IP that we see in companies? I think this feels natural to most people, but of course, if you're a products company, of course, the widgets that you're designing and building, those are going to be IP that you're going to focus on. Processes, of course, can be potentially patented software, materials and compounds, biotech subject matter, and of course, there's overlap between all of these, right? I mean, their software and processes are almost one and the same, not quite. But the one thing to think about though is of course you have your primary product, right? You're building some sort of widget. You want to make sure you're also considering protection for ancillary innovation. Okay, so an example of that would be say you're in the precision ag space and you develop this really interesting farming implement that has some mechanical innovation to it. I mean, its design looks different and operates differently just mechanically than anything that's out there, right? So you're like, hey, that's patentable. Let's go get that. But you also want to make sure you're thinking about things like, the algorithm that you made, the machine learning material or subject matter that you plugged into the thing and developed that's also innovative. You want to make sure you're covering that as well. And that maybe that's married to the farming, the mechanical aspect of the farming implement, but they kind of work hand in hand. You want to make sure you're covering both of those things. And that may not even really be all that ancillary. That may actually just be, primary one and primary two in that hypothetical. Some very classic ancillary cases would be in the case of, say, the precision ag farming implement is maybe you have to make some component of that farming implement in a very unique way, right? So there's a method of manufacturing to it that maybe you can use to increase the size of your moat around your company. And the other practical reality is you're not guaranteed that you're going to be successful, right? So maybe you go after your primary invention and maybe you don't get that patent, right? I mean, it may be years before you know the answer to that, but maybe you can't get that patented. So it's nice to have that backup. So just imagine, play out that hypothetical. Say I have this mechanical contraption that I file a patent for that, and I can't get it. There's too many other things that just look too similar, and the patent office is really pushing and just will not let us through on this, what we call an obviousness ground. Maybe there's that component that you have to make in a really weird, crazy new way that is definitely patentable. And so you can kind of monopolize that space because you own the method of manufacturing that thing. So that's still pretty good, right? And so you want to get both, but if you have to settle on one, that's not a terrible place to be. So just keep that in mind. And now all of that subject matter, whatever it is, we have to map that to the actual legal regime that exists. And in the United States, what we have is we have utility patents, design patents, and plant patents. Very quickly, utility patents cover machine processes, article manufacturers, composition matter. Design patents, not surprisingly, cover ornamental designs for articles of manufacturers. And then plant patents cover asexually reproduced, distinct, and new plant varieties. So utility and designs are by far the most commonly used patents in the United States. Plant patents exist, and certainly in the ag space, that's where they're going to exist. They're just very, very few of those filed. And I want to mention because they exist, and there may be somebody that might utilize, we could potentially leverage those. But plant patents, I wanted to be very clear. These aren't biotech patents. These aren't, plant patents that when you want to cover a particular new, I don't know, say you genetically engineer a new plant, that's going to be covered under a utility patent. Plant patents are kind of like a design patent for plants. They're actually protected by using pictures and or drawings of the plants, and that's really how you distinguish them. So they're very kind of odd. I almost said weird, but they're weird, and they're a little bit archaic. But there are certain companies that utilize them quite a bit. But I think I've filed a few of these in my career. So, but when speaking to a group focused on ag innovation, plant patents, I think should at least be mentioned. But utilities and design are the focus.
Matt, we have a quick question.
Oh yeah, go ahead.
On this. Chelsea asks, if you patent a process, does it then become public knowledge?
Yes, it does. And that's a good question. And good question. And as it relates to the interplay with trade secrets. So if you have a unique, process in place to I'm just throwing out a hypothetical, process some sort of material, right? And it's something that you can keep secret. It may be something that lends itself more to trade secret protection than patent protection, because ultimately, when you file a patent application, you can do what's called a non-publication request. So it doesn't publish, but it does. That's just during the examination process. Once it gets to the point of issuance, it has to publish, and so then it ultimately be known to the public. And you have to include certain amounts of information in order to meet the requirements, and usually you won't like that. It's a trade-off, right? Now the catch is trade secrets aren't they don't protect against reverse engineering. So or just independently developing it. So there's another entity out there, a competitor that develops a similar process with the same process, either accidentally or somehow by reverse engineering your end product that comes out of that process. Trade secrets don't protect it against that. Trade secrets really protect against things basically like the illegal acquisition of that intellectual property. So most common place where this is used is a former employee leaves your company and they signed an NDA that says they won't, the NDA is semi or quasi requirement of trade secret law. They say that they will not, share any information related to this proprietary process, and then go get hired by a new company and then share it with them. That can trigger trade secret protection or trade secret cause of action, but it's really limited to those cases. So patents cover much broader, but they have a term of 20 years, and so trade secret law has no term, but it's very narrow in terms of when it can be applied.
Great. Thank you, Matt.
Yep. All right. So ultimately, what do patents cover? I think there's a bit of a misunderstanding sometimes in the public that patents cover, or based on the title or the drawings of the patents that are in the patents, and that's not the case. Patents or claims are what define the scope of the patent, and ultimately determine what an owner of the patent can exclude others from doing. Right. So a little bit, if you make the analogy to real estate, patents are kind of like the plat map is in real estate. It defines your borders of ownership. Now that's a little bit messy in terms of patents, particularly in utility patents. Designs are a little more clear to me. Utility patents, the claims are all defined by words, and specifically, if you look at any patent, there's a section that's called, basically listing of the claims. And so it's language like this on the left side. I'm not going to read all that, but the point is it's filled with a fair amount of legalese and somewhat, thick and hard to understand. That is what is defining the owner of this patent. That's what defines their right. That's what they can stop people from doing. But in order to infringe that patent, a would-be infringer has to be building, in this case, building a device that includes all of those elements. And only then is there infringement. So there's the goal when you write a patent is you want it as broad as possible. And the way logically, that means you probably want it to be as small as possible. The fewer words, generally, the more narrow the claim is. And so that's how patent claims work. It's not defined by the picture on the right. It's not defined by the title on the top. Although to the extent you ever hear about patents in the media, that's what they focus on. And in fact, it's not even the drawings, it's just the title. Apple patents, touch screen smartphone. And then everybody thinks that Apple owns all touchscreen patent or touchscreen phones in existence. And that's just not how it works. It's much more specific than that. Now, design patents, touchscreen was a good example, are defined by drawings. So I just said they're not, patents aren't defined by drawings. I meant utility patents. Design patents are defined by drawings. That is the claim. Actually, the drawings are actually the claims. Now, you can modulate the scope of your protection though by using solid lines versus dotted lines. And so if you ever pick up a design application, look at it, if you can remember this far back, solid lines are considered the claimed invention. Dotted lines are unclaimed or often provide context or just general background. So that's the way those operate. And I would say design patents are gaining a lot of popularity in over the last decade for a couple of reasons. One, infringement analysis is much simpler in designs. It's really the ordinary observer test. If an ordinary observer looks at the patent and looks at the product and says, yeah, I think that product infringes that patent or those drawings in that patent, that is pretty much the standard. If the ordinary observer, which is kind of the normal consumer of the product in question. And so it's a little more logical, but the place that's really caused it to grow is online. And so companies like Amazon, right? They sell millions of products every year or broker those sales. And because of the rules that are in place, they can get in trouble if they willingly allow infringement to occur. If you have a product like a consumer product that you put on Amazon, going to get a design, it makes a lot of sense because you can actually submit that design to Amazon's offices and they will go and pull the competing products off the site. and it's kind of a quasi judicial, right? It's obviously a private entity that's much more efficient than going to court. So to the extent you're selling those types of products on Amazon or Alibaba or whoever, it's really valuable. Now, in the ag space, you're probably not selling, a center pivot irrigation system on Amazon, but general point is the same. You can sometimes leverage designs in ways that you can't leverage utilities. So they definitely something that shouldn't be overlooked. Okay, so kind of time is kind of burning up on me here, but the general patent process, and I'm going to zip through this a little bit. Conception of the invention, that you've invented something. From there, the next step is typically the invention disclosure process, which is more of a formal thing, and that's kind of your goal here, is to start formalizing some of your IP efforts. And I'll talk about that a little bit, but I'm going to probably zip through the next slides and kind of leave them more for reference. Patent search, once you get to the point where you really think you have something there, the next step after you formally disclose the invention. When I say formally disclose, I want to make sure it's clear. I'm not meaning to the public. I mean probably to your patent attorney, or to your internal team. Patent search is the next step. Then usually the provisional application, like we've discussed, then the non-provisional, then examination occurs, and then ultimately, if examination is successful, issuance. And I'll talk about each of these steps quickly here. Invention disclosure. Most patent attorneys will have one on hand that they'll usually share with you. The general point is just to systematically capture your inventing. Now, early on, when you're the only founder of your company, or you're the founder of the company, you have no employees, no junior engineers, pretty much what's going on, right? You are the innovative source. Now, as time goes on and you start to grow and you bring other people on board, you don't always know what's going on, or at least not as intimately as you'd like. Using IDF is a good way to kind of formalize that innovation capture and track it. And that is really pretty, it sounds boring, but a lot of the most important things in life are. It really does help with formalizing innovation harvesting. But general point is it includes a description of the invention in a way that enables one of our skilled in the art to make and use the invention. And it helps the inventor to sit down and think about it. Again, maybe not as important for the founder to think about, but maybe a junior engineer who just came on, who's building one little widget that goes into the larger system. That one little widget by itself might be a new invention, even though the larger system has already been filed on. So it's something that it's never ending. It's just a progression that occurs over and over, assuming that innovation is happening at your company. The patent search sounds kind of obvious, I think, to most people, but the general point is your attorney that's doing the search is trying to replicate what the USPTO is going to do. And it's a bit of an insurance policy. Generally, we don't find what we call knockout art. Knockout art is like, hey, somebody else is doing exactly the same thing, and we found it, here it is. Even if you don't find that, which is honestly, you don't usually, where the patent search really helps is it helps define what the prior art looks like, which then when you prepare the patent application, it allows the attorney to really kind of find those nooks and crannies in the prior art that help you define your patentable subject matter. So when you go to the patent office, you have a smoother sailing ride with the examiner. And just universally, it's one of the most valuable things I think you can do. It just helps set the stage, set expectations, and just sets you up for success as you go through. Now, provisional patent application, as we talked about earlier, a little more formally here, but it acts as a placeholder typically. Well, by definition, it's a placeholder, but sometimes it's a shorter placeholder than other times. It acts as a placeholder. The biggest advantage is it can quickly allow you to avoid a barring event, just like Josh's hypothetical a few minutes ago. That's where it has its most value. It's usually cheaper than filing a non-provisional application directly. But some other big advantages is you can file multiple provisionals. So if you file a provisional, say you're getting ready to go to a pitch event, hey, we need to get a provisional file. We're going to file a provisional on what we have, right? This is where we're at. We're going to file a provisional. but to avoid that barring event. And 6 months later, you may be evolved, right? You've really changed the design of the product, whatever it is. Well, we need to capture that new subject matter, but you can capture that in a new provisional. And lots of times, practically speaking, you just take the old provisional and we update it a little bit and file a new provisional. Okay. And then when that 1 year date comes up, you file the non-provisional. On that non-provisional, claims priority back to the first provision or the second provisional and the first provisional. And then you have both of those in that chain of priority. And that's harder to do if you just start with the non-provisional. It's just administratively, it's harder to do. And so that first year, and that's where, like, from a growth and like change in events perspective, that's where everything, things just happen way quicker at that stage than they do later. And it's just really nice and convenient to be able to file multiple provisionals if you need to, and give yourself that year to evolve the product, get some momentum in the market or with investors, whatever it is. And then, when that year's up, then worry about the non-provisional. So then you get to the non-provisional stage. Again, you have to file it within a year. It is usually more expensive than a provisional just because more formalized, a little more legalese. You have to formalize drawings, do those kind of things. If you do add new material at the non-provisional stage, then the priority for those claims that are directed at that new material is going to be the date of the non-provisional application. So that can have some impact potentially. If a competitor came online after that new information was disclosed, then or brought into the file wrapper, then that could potentially be problematic. And that's why you want to capture that as soon as you can through the multiple provisionals that we talked about. Kind of moving along here, so I can try to get at least through the patents. We may end up being short on the trademark stuff. Next question too is foreign filing. This is something that always comes up, and I'll keep this short. General point is you have to initiate some sort of foreign filing application within 1 year of your earliest filing date. Again, in the typical case we've been talking about, that you have a provisional that within a year you have to file a U.S. non-provisional. At the same time, you have to initiate that foreign filing effort. That's in basically two forms. It's the PCT. It was kind of considered an international application, and then a direct filing through the Paris Convention. Now, the PCT is now by and far the most commonly used version, and that's because the PCT itself is never really examined. It's kind of an international placeholder that buys you an extra bit of time. So if you waited 12 months to file that PCT, you actually get yourself another 18 months before you had to nationalize it in the individual countries. So it's just another mechanism to push expenses down the road as long as you can. But foreign filing is something you'll have to talk about a year after, or with 9 to 10 months after you file the provisional application. All right, requirements quickly, and I do have several slides, extra slides at the end that kind of talk about each one of these bubbles, so you can dig into that a little more if you'd like. 102, 103, 112, 101 are the biggest standards we're worried about. 102 and 103 are prior art sections, and it's really, is your invention new and non-obvious, and that's the general standard. I'm happy to answer questions about what that means, but really, is somebody else done this before? And if someone has done something similar, is your invention obvious to those efforts, relative to those efforts? So that's kind of the layman's way of stating that. Enablement is really, have you provided enough information in your specification so that someone can make and use the invention as you claimed? And then 101 is really subject matter eligibility question. Does the government allow people to get patents in this space? And that comes up most often in biotechnology work and in software. And happy to talk about that in more detail in questions or later. So assuming you do all that, you go through the whole examination process, you satisfy all of those thresholds, you get a patent. That's what will happen. This is what it looks like. Take a good look, because they're getting rid of these. They're going to start issuing these electronically. You can still get a gold seal one, but it's an extra fee. Government never misses an opportunity to charge you or hit you with an extra fee. But I'm guessing, and after a while that they'll take that away too, but you know, they're transitioning this right now. And which is kind of sad because it's nice to see these, they come in, you know, every Tuesday, every week, basically. And it's nice to hand these out to clients. So I'm at 1:45 here. So I'm going to skim through just some high level trademark stuff, 5 minutes of it, just to give you a taste of it. There's a lot of slides in here, which are, I think, are pretty easy reading, probably worth taking a look at offline. But, you know, trademark is the other big issue or other big area that startups need to think about. And patents don't apply to every startup, right? I mean, you have to be, you know, working in patentable eligible subject matter to really have to get too worried about patents. Trademarks, though, anybody who has a company, anybody has a logo, a brand, a name, probably has to think about trademarks at some level, right? At a minimum, infringing other people's trademarks. So, you know, we'll talk about the basic definition of trademark and then some questions, and some details, a little bit of details about the selection of a mark. I think that's always a big takeaway for trademarks that I like to share with people. But general point is trademarks are any artifice indicating the source of good or service. You can get federal marks, state marks, and then common law marks, which are acquired through use, and then recognized by courts ultimately. But use in commerce is what establishes the priority. So not just use, you can't just draw a logo up and then call that use in commerce. It actually has to be use in commerce, which means you're actually trying to you're tying that brand element, often a name or logo, to the actual sale of some good or service. You can actually file what's called an intent to use trademark application in the federal system, which kind of provides constructive use in commerce. And that is an advantage that does put you first in line, but it doesn't beat out people who've established real use, even if they haven't registered. So they can potentially object to your filing, but it does beat out other people who haven't used. So there's an order, there's a hierarchy in terms of what has the most weight. But and then finally, self-barring event. There are no self-barring events with trademarks, unlike patent law, right? In fact, trademark law, you have to use in commerce to actually get it registered. So that's it's kind of works a little almost opposite of the way patents work. I'll let you read that general point, but a trademark is a word, phrase, symbol, logo, and or design that identifies and distinguishes the source of goods. Ultimately, trademarks are consumer protection. They're meant to tell the consumer who's making this good or service or providing this service. And go ahead and read that when you get a chance. But trademarks and service marks are technically different, although we actually just treat them the same in terms of practice. General protections here, I'm going to go ahead and skip that one. General point is if someone else is using a sufficiently similar mark, you can enforce your mark rights against them. And the bigger practical pieces I want you to take home are right here. Again, when someone comes to my office and they're interested in trademark rights, this is kind of the script we would go through. Are you using in commerce, which we talked about briefly? What are the goods and services? Marks are defined or split up at the trademark office based on the types of goods and services you're offering. They put them in different classes, and you may be providing multiple goods and services, right? You may be providing a good and a service. You might be providing multiple services and you don't even know it, right? You have to divvy that out in the way that the trademark law looks at it. Is a mark distinctive? That is an important point, and I think that helps people guide them in terms of what marks to pick for their branding elements. And is there a potentially likelihood of confusion with any other marks, right? That's kind of like the prior art version of the patent law, right? That's kind of like, is anybody else that already done this or doing this? Am I going to be conflicting with anybody else's activity? Very, very high level with the trademark process looks like. You select the mark, you apply for the mark, it's examined, it ultimately registers. You can keep it active in perpetuity by maintaining the mark. Every so often you have to pay a maintenance fee to the trademark office, but as long as you're still using the mark, you can get it renewed. And then ultimately, if you have good mark rights, you can enforce those rights against other people. The selection of the mark. This is the part I think that is pretty informing to people or use. It's very practical. Maybe it's even a little bit silly, but the mark must be distinctive, and distinctive marks are considered. There's kind of a spectrum of marks. There's fanciful marks, arbitrary marks, suggestive marks, descriptive marks, and generic marks. And the trademark office pretty much splits any mark into one of those categories. Now, fanciful marks, arbitrary marks, and suggestive marks are considered inherently distinctive, right? Descriptive marks are not distinctive, but they can get trademark protection if you establish secondary meaning. Like if there's enough evidence that people look at your brand and say, yep, that I associate that brand with those goods and services. Even if the mark itself is descriptive, you can get trademark protection. Generic marks, you can never get protection on. Now, just to skim through these, I know we're sort of running out of time here. Fanciful marks are just that. They are words that just had no meaning whatsoever prior to the advent of that mark in the marketplace. And honestly, these are like the best marks. These are the marks that only exist in your head because somebody made it up and associated that with marketing to that particular product, right? Xerox, that's a pretty, not as strong as it is now, or it used to be, but that used to be a very, very strong brand. Arbitrary marks. These are marks that the words exist like in the English language, but they have nothing to do with the products. You know, Apple, obviously huge, strong mark, which had some conflicts with record company, but very strong mark in terms of just the strength of the mark. Tide, Monster, all those types of names, Uber, like those are names that are just completely arbitrary, good, strong marks. That's where the value is the company's association and work towards associating that mark with the good and service. Suggestive marks are like things like Netflix, KitchenAid, Microsoft. You know, the words like Netflix and KitchenAid, they kind of suggest where the product resides, right? It's like the KitchenAid one, right? It's this mixer, KitchenAid mixer. It's in the kitchen, right? It's not descriptive. It's not saying a kitchen mixer, but it's KitchenAid is kind of suggests where the product resides in the universe. But suggestive marks can be registered, to be clear. But those are starting to get a little closer to their line. Descriptive marks, these are ones that they're just describing what product or service you're selling. Burgers and brew for a restaurant, right? We sell beer and we sell burgers. Like that's pretty descriptive of what you're doing. Now, luckily it's not completely generic. You can ultimately get these trademarked, but it's harder. And frankly, I think they're less valuable because other people, you know, what if you had a company that was a lot of times you have to disclaim subject matter, which means you're not claiming the specific elements because it's so common. You know, Tony's Burger and Brew, they might still be able to get a trademark on that, and you just have burgers. I mean, it starts to become hard to distinguish where those fanciful and arbitrary marks are so much better. And so much easier to establish infringement because nobody else should be using anything close to those, right? Where you're just going to automatically in SEO, for SEO purposes, you're going to get a lot of overlap with other companies using common words. And then generic marks are just, it's absolutely, it's too descriptive, basically. It's beyond just descriptive. It's completely generic to what you do. If your name is The Bar, that's completely generic to all other bars that exist, right? Now the crowbar is something that's probably more descriptive, but that element, the bar, is almost definitely going to have to be disclaimed, which is kind of beyond the conversation here. I know we're running out, so I'm going to try to feather in a couple of these other points. One of the designator is another big question people have. When can I use, or when should I use certain designators? The TM on the left, that is, you can use that basically anytime you start using it at all, right? You put it on the website, whether you filed for a federal registration or not, you can use TM, okay? Or SM in the case of the service mark. If you wanted to make the designation, you can. Otherwise, just use TM. It's not a problem. The circle R, you can only use that after you have federal trademark registration. Like, not application, it actually has to be successful and registered, and you actually have to have the registration certificate. If you use it too early, then you potentially can actually lose the registration or be denied. There are situations where I've had specimens you have to submit to the patent office or trademark office that shows that we've been using this in commerce, right? Which are pictures of your logo or your brand being tied to the sale of goods. And then the client will have pictures and then their logo, they have the circle R next to the name, and that we haven't even filed the application yet. And so that's problematic. And usually you can convince the trademark office it was just accidental. The client didn't know, it was not intentional. But if there's any evidence of actual deceit, then you can have real problems. Trade dress, final point, and man, just got kind of ran out of time here. I say all of this. I said early on that things overlap. This is an example of that. Trade dress is a subset of trademark law, and it's all based on look and feel of the article that we're talking about. But ultimately, it's a source identifier. So you look at the design of the thing, and you look at that, and you know what company made it, right? And so, classic example is a Coke bottle. Well, Coke also had design applications on the Coke bottle, but those design applications ultimately expired after 14 years. And their trade dress, they could keep renewing over and over and over and over. So when we're thinking about those types of products that have design elements that are interesting, trade dress kind of is hand in hand with design applications sometimes, and you need to kind of think about both sides of it. I always like throwing this one in because it's just kind of where everything kind of comes back together, back to my first four bubbles. We talk about the overlap, and it also highlights the complexity of some of this and how you just have to work through it. And all cases are unique, so you have to work through on a case by case basis and hopefully get to an answer that, and a lot of it's hodgepodge. You gotta just look at it and say, what kind of protection can we get? We can maybe get a design application, maybe we get a trademark, maybe we get trade dress, or no, you're absolutely can get a utility patent. There's no design here because you're working in the algorithm space. We can get a utility patent and we can get trademark protection. So you just got to cobble together the best IP portfolio you can, all while trying not to break the bank and keep things as cheap as possible for as long as possible. And there's strategies that we talked about throughout somewhat quickly to do that in terms of provisionals and using the PCT to delay entry into national stages and all that. But it's a kind of a game we play is to push expenses as far down the road as possible. I guess with that, I'm going to wrap it up. So I have at least a couple minutes for questions. And I know we kind of pushed the envelope on the time there.
Awesome. Great job, Matt. Thank you so much for going through the presentation. We do have a couple submitted questions in advance, but also another one here in the meeting chat. So Chelsea asks, how long does the trademark process take?
Yeah, the trademark process. I mean, if you filed it today, if you have a trademark application ready, you filed it today. Not too long ago, you were getting responses from the trademark office like in 3 months, and that was great. Now they're like a year. It just really goes up and down. So I tell people about that 3 months to 3 to 12 months, and it depends who you get as an examiner. But they've been really slow lately.
Perfect. And also, so everybody knows, we will be sending out this deck. Is that okay, Matt, to everybody?
Yeah.
And also, we will share Matt's email if they have any further questions, but we still do have a couple more. Jackson asks, how much substantiation does a provisional patent require? Do you have to have data to prove that a concept works, or do you simply have to have a reasonable concept?
Yeah, it depends what we're talking about. So if you're talking about a new mechanical device, it's very, you see an image of it and everybody will understand how it works. You don't need to have as much of that workup involved. But the ultimate test is the enablement test. And do you enable, and I'm using air quotes because that's the word they use, is do you enable those of ordinary skill in the art to make and use the ability to make and use the invention? Now, those of ordinary skill in the art, that's not the ordinary observer test in design. Ordinary observer, if you're working in the algorithm space, is going to be probably a typical computer science guy, computer engineer. Is there enough information in there for them to make and use the invention? And so it really depends on the subject matter area. The more black box-ish that the thing can be, the more you need to provide. So machine learning, stuff like that, you need to have a little bit more stuff. Otherwise, it starts to feel like a black box. It's just inputs and outputs, and the magic is inside this box that we really don't know how it works. Same thing with biotech stuff. It's in terms of genetics, you got to really tie functions to genetic sequences and things like that. And if you don't, it starts again, it feels like a black box. And that's kind of how the trademark or the patent office looks at it. Mechanical, electrical stuff, they tend to like, hey, if you look at it, you look at a circuit, you know how it works. You don't have to you don't have to explain every little thing. You don't have to talk about how electrons flow. So it's just kind of a case by case analysis, but ultimately the test is, think about it. Okay, if I was a computer engineer working in algorithms, if I'm a computer engineer off the street, would I be able to read this and understand how to make and use it? That's kind of the threshold.
Perfect. And one of the submitted questions ahead of time was, what does a first meeting look like with you? And also, how can a startup be expect to be billed during these types of meetings as well?
Yeah. So, first meeting for me is startup folks either set up a Zoom meeting or call or come into the office, or if I'm in Lincoln, which I get to Lincoln pretty regularly, I'm around in town, I can stop by if that's where you're located, which may or very, very possibly isn't the case. Set up a meeting. We talk. I want to hear about what you're working on, what you think is innovative, what you think is from a branding perspective you're wanting to work on. Whatever the issue is, I want to hear about it. And my initial meetings, I don't bill those. And particularly, I rarely bill those initial meetings for any client. For startup clients, I very rarely do it. For local startup clients, I never do it. And for combine startups, I definitely never do it. Though that's part of I'm from Nebraska. I grew up in rural Nebraska. I want people in the combine and other startup groups to do well. And I just, that's part of it. I guess giving back a little bit. I don't usually bill those meetings, and we work hard to keep the billing down, particularly for combine folks, to keep that billing down pretty substantially relative to kind of open market clients, I guess.
Yeah, that's great, Matt. Thank you for going through that. And another topic or another aspect of that as well. We have a question from Val. What is the timeline or expectation for provisional patent application to have it granted?
To have it granted?
Yes.
So with the provisional application, those are not examined. So it's purely a placeholder function. So you file the provisional, and that you get a provisional serial number. And then when you file the non-provisional, you incorporate by reference that provisional. Okay, so the non-provisional is then treated as though it's filed on the date that the provisional was filed, and incorporates everything by reference. And then you submit the non-provisional. The non-provisional is examined, and that's how that process works. Just want to be clear on that. Now, the provisional that does become publicly accessible once the non-provisional that incorporates it is published. Just so you know, it's not always secret. It's just secret until the non-provisional is published. And then, but in terms of the timeline, the more practical question I think is, if you file a provisional, when will my patent be granted? It won't be the provisional that's granted, it'll be the non-provisional that's granted. But if you file a provisional, if you wait a full year, which that's up to you, you don't have to wait a year. You wait a full year, then you file a non-provisional. It's usually about, you can think about, I would say, I've had them granted as quickly as 3 months, but the realistically, they're not granted until I would say 12 months to 2 years after the non-provisional. So if you wait the full year for the provisional and add that up, you're talking about, I would say, 2 to 3 years from the filing of the provisional. Now there are ways to accelerate all of that. You can skip the provisional. You can do the provisional only for a couple months. You can definitely compress that time. When you file a non-provisional, you can file an acceleration request. It costs a couple $1,000s, but they basically guarantee examination within 3 months. Theoretically, you could today, if you filed an accelerated non-provisional right now and skip the provisional, you could potentially get it issued in get it issued in 5 months, get it examined in 3 months. which obviously is a lot faster than 3 years. So it's kind of a spectrum.
Perfect. And Matt, can you talk a little bit about, the success that you and your company have had in this area?
Yeah. In patents in general, I think we've been in business now for 30 years. I've been here for 15 years. We've had just regionally, I think we've issued more patents than about any firm in Iowa, Nebraska, South Dakota, Kansas. And I think if you even expand out to Colorado and Kansas City, Missouri, we're still like in the top 7 or 8. So we're pretty seasoned firm. We focus solely on intellectual property. 3 of the 4 partners are from rural Nebraska. So we all have, I would say, a pretty good connection to agriculture. And 3 of the 4 partners, different group of 3, are all from the University of Nebraska. So we have ties to all of that. And so this is a very natural group to work with for me. And we worked with tons of startups coming out of the area. I mean, the nation too, but a lot of startups, a lot of the big, I don't know if you call them big names, but bigger name startups have come out of, the Nebraska area in the last few years, and we've been involved with most of them. And it's just, I don't know, it's just nice to work with people that there's some commonalities with, and you're getting, when you work with us, you're getting attorneys that know. I always try to make some ag joke, that know the difference between center pivot irrigation and a steer, because there are some lawyers that don't know the difference between those 2 things. So or that they even exist. So that's kind of where we're at with it.
Perfect. And we're out of time, but we will send you some more questions that we've had from the audience. But Matt, thank you so much for lending your time today, and thank you everybody for coming. And we will send out your information to everybody so they can get in touch with you.
All right, that sounds great. Thanks for having me, and wish everybody a good rest of the week.
Great. Thank you so much.
All right, thanks guys. Take care.